The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel.
Good morning.
Please proceed.
Thank you, Your Honor. Eric Brignac, may it please the court, Eric Brignac for Christopher Lancaster. In Chambers, this court correctly held that, quote, it would pervert Congress's intent to maintain a career offender designation that it is as wrong today as it was at the time of the original sentencing. This court also correctly said that it was an extreme position for the United States to argue in contrast that a court must perpetuate a guidelines calculation error that was an error even at the time of the original sentencing.
Excuse me.
Yes, Your Honor.
Excuse me, this is Judge Quattlebaum, and I'm having real trouble hearing you now. It's very garbled, and I don't know if the other judges are having the same trouble, but something changed from what you said earlier and once you started your argument.
See, I can pull it a little closer. Does this help, Your Honor? Or I didn't change anything in my computer, so.
that sounds better. Thank you. I'm sorry if that others could hear, but that sounds better. Thank you.
Yeah, thank you, Your Honor. I may have leaned back a little too much. So thank you so much for getting ahead of that. So I'll just pick right back up. In Chambers, this court held that it would pervert Congress's intent to recreate a guidelines error that was error at the time of the original sentencing and is error today. This court also held that the government's argument to the contrary was an extreme position to force a court to perpetuate a guidelines error that was an error even at the time of the original sentencing. And
how is it an error even at the time of the original sentencing?
Your Honor, the error in this.
But I thought we were talking about intervening authority between the time of the original sentencing and the First Step Act hearing.
It is, Your Honor, intervening authority, but critically, just like in Chambers, it was a case that clarified what the career offender guideline always meant. We are not asking this court today to apply any guideline amendments. We are not asking this court today to apply any statutory amendments other than the Fair Sentencing Act, nor were there any, we're not asking this court, because it's not before the court today, to apply a different guidelines manual. It is the exact same statutes and guidelines, word for word, that applied in 2009. The only difference is that we now understand, in a way we did not in 2009, what those words mean. The federal conspiracy is not a career offender predicate, and it was never a career offender predicate. That was the distinction that Chambers made. And
counsel, do you contend that the sentence could be vacated because we now should apply Chambers to a non-retroactive change in law, or do you contend that the rule from McCullough and Norman is retroactive and therefore compelled by Chambers?
Thank you, Your Honor. The rule from McCullough-Norman has not been held to be retroactive, and that question was not briefed by the parties. So we are not here today relying on the idea that Norman's retroactive. We are relying on the language from Chambers. And obviously the government's response, this is all centering around the question of retroactivity. And I think it's critical. Let's look at exactly what Chambers said. And this is page 672, 673, when it explains why the retroactivity there mattered, it did not get into Teague v. Lane. It did not get into 2255. It did not get into technical habeas finality door opening. Instead, it said that it mattered because, and this is a direct quote, because the error in that case, and they're talking about the Fifth Circuit case in Hedgewood where it wasn't found retroactive, may not have been a mistake at the time of the defendant's original sentencing. So what this court was doing in Chambers is saying that because this error was retroactive, and because in Hedgewood it wasn't, that perhaps the error in Hedgewood was not an error at the time. But we can cut through all that, and we know that the error was an error at the time because it was found retroactive.
But how was it an error at the time if it was not recognized as an error at the time? For example, if it was not recognized as an error either at the sentencing or if someone had taken a direct appeal, it wasn't recognized as an error during the direct appeal. And if it may be that the wording of the career offender statute has not changed, but if the interpretation of the guidelines provision has changed from one thing to another, because the law is not simply the provision, but how the provision is interpreted. And if the interpretation of the provision changes, then don't we face the question of applying a non-retroactive guidelines error retroactively?
Thank you for that, Your Honor. And respectfully, I have two responses. First, Your Honor, the government could have made the exact argument you made. The government could have made that argument in Chambers. If Mr. Chambers, at the time of his original sentencing, had said, hey, you're calling this a felony, it's not a felony. In North Carolina, under North Carolina's bizarre sentencing scheme, this is not punishable by over a year, he would have lost that at the time. It turns out we were wrong, and this court clarified that in Simmons. Secondly, Your Honor, I would look at page 2-3 of our reply brief, and there we cite Rivers versus Roadway Express. It's actually a relatively common canon of construction that when a case interprets a statute, it doesn't just say, or in this case, a guideline, what that statute or guideline means going forward. It's a declaration of what it always meant.
But isn't there, there's an agreement, isn't there, that there was a guidelines error in the case, that there was a guidelines error, and I assume also there is an agreement that the particular guidelines error here, nobody has contended that it's retroactive. And so I wonder if we're not faced with the basic question of whether Chambers requires district courts at the time of a 404B First Step Act hearing to apply non-retroactive changes in the guidelines. And you seem to be moving the issue around a little bit, but I'm wondering if we are not faced squarely with the question of whether, however it's answered, of whether Chambers requires the district court to apply to First Step Act sentencing non-retroactive changes in the guidelines. And I was under the impression that that there was in the intervening time between the original sentencing and the First Step Act hearing a change in guidelines interpretation, and McCollum came along and indicated that there was an error, and so there seemed to be a consensus that there was an error, and at the same time, there seemed to be a consensus that there was the error was non-retroactive. But isn't that the question that we squarely face?
Yes, Your Honor, we are squarely faced because Norman has not at this point been declared retroactive. We are squarely faced with whether Chambers requires this. And it does. Your
Yes.
Honor. Yes, we are. And it does because Chambers says you must calculate the guideline range correctly. Apply the old law, in this case the 2009 law, and calculate it correctly. And when you are doing that, you are not obligated to make the same mistakes that you made at the time. And the word retroactive, Your Honor, if I may continue, I think is confusing the issue here. And I think it's a bit of attempting to place a square peg into a round hole. Retroactivity, as a legal term of art, applies in the 2255 Teague v. Lane context. And what it does there is it says, you know, every federal defendant, when he's convicted, can file a 2255 motion. You have a very large funnel at the front end. Everyone within a year can file one. Retroactivity narrows that funnel at the bottom. And it says, for certain errors, you only get to come back into court on a 2255 collateral attack in this narrow class of retroactive errors. 404, Your Honor, is different because Congress has answered the question that retroactivity would otherwise answer. Congress has said for this very narrow group of individuals who fall into this time zone of having a crack offense where they didn't get Fair Sentencing Act relief, they do get to come into court. Finality is upset. We do not have finality here.
It's upset to a limited extent.
Yes, exactly, Your Honor. It's upset to a limited extent.
It's up to, the question is it only upset as to the Fair Sentencing Act of 2010? That's what the debate over the as-if clause was all about.
Yes, Your Honor, and obviously there's a pretty down-the-middle circuit split on that question. This court came down on one side of the split in Chambers. This court denied en banc rehearing in Chambers. So, I mean, that's certainly a huge question, but it's a question that this court asked and answered.
Counsel, if I could, Judge Wilkinson's question and your answer, I mean, I think you would say that, you know, because of language, you know, outside the holding in Chambers, that we are bound to apply, you know, other aspects of it to non-retroactive intervening changes in law. And I realize you didn't brief this, but I really, and you don't, I guess, have to answer it, but isn't there a pretty good argument that Norman and McCollum are retroactive because, one, they, as you alluded to earlier, you know, clarify law and there's thus a old rule under the whole, you know, league, type or Teague type cases, and two, because it's a substantive rule that alters the class of persons, you know, that are career offenders. And if that's the case, do we really have to extend Chambers? Or because, I mean, Chambers, you may say retroactivity is a red herring, but you want to rely on Chambers to avoid the circuit split question that Judge Wilkinson just raised, but you seem to not want to stick to its holding that it's retroactive. And I wonder if we really have to extend it based on the way retroactive law has been considered in other ways.
Your Honor, I do think that that Norman rule would be found retroactive. I do think it is a close case, and I'm sure the government has opinions on this, because it would be just a guidelines error as opposed to Simmons, which happened to be a statutory and guidelines error. And certainly if this court wants supplemental briefing on the question, we would be very happy to provide that. Our position is that we do not think it is necessary because the retroactive, non-retroactive distinction is about finality, and Section 404 asked and answered finality. And to my knowledge, every other circuit, no other circuit considers this retroactive or non-retroactive distinction to be the linchpin on which Section 404 rises or falls, whether you get to fix.
Well, what about the Fifth Circuit case, which made an explicit point, and Chambers itself says that the Fifth Circuit case, I forget what the exact name of it was, that what it was dealing with was the question of retroactivity.
Yes, and Your Honor,
That was the linchpin.
And again, I do not think that that's where this court went in Chambers, and I'm sorry, Your Honor, I'm not sure exactly which Fifth Circuit case.
It's the Hedgewood case. I mean, Judge Wilkinson's right. The Chambers case, talks about the first reason Hedgewood's not persuasive is that the issue there had not been deemed retroactive. I mean, he's exactly right on that.
And Your Honor, may I answer that? My red light did just come on.
Yeah, you may answer it.
Thank you, Your Honor. So, and I'm glad you pointed to that language, Judge Quattlebaum. First, I would say two things. Hedgewood said they relied on the as if language to say that you don't apply any other changes. So I'm not thinking that Hedgewood itself actually relied on retroactive, non-retroactive. And then I would look at the top of page 673 in Chambers, where it says the intervening Fifth Circuit case law that would have removed Hedgewood's career offender enhancement has not been declared retroactive. And then here's why this court in Chambers said that. Hedgewood, therefore, does not squarely address the question presented here because the error in that case may not have been a mistake at the time of the defendant's original sentencing. So I would say, Your Honors, that it is not retroactive in Chambers, was not about whether we fit into the Teague v. Lane box. It was a
in this case, we have a clear ruling of retroactivity because you have Simmons, which indicates the retroactivity in the Chambers case, and you had Simmons, which clearly indicated the retroactive nature of the error, and then you have Simmons, I think, indicated the error, and then you had the other case, Miller, following on Simmons, which indicated that the Simmons rule was retroactive. And so that was what Chambers was dealing with in that context, which was a Simmons error that had subsequently been ruled in Miller retroactive. And that's the narrow question that it was dealing with. And you don't have that here. You don't have any clean ruling of that the error that we're talking about in McCollum or whatever is retroactive. Well, you have a clean ruling in Chambers that the statutory error there was retroactive, and here you don't have that. So is that a ground for maybe not distinguishing Chambers, but limiting it, because that was the question with which Chambers dealt, a clear ruling of retroactivity.
And Your
Here we
Honor,
don't have that. In fact, we have a consensus that the guideline error is not retroactive. Aren't those different situations?
Your Honor, to bounce off of Judge Quattlebaum's point, I do not think I think whether Norman McCollum error is technically retroactive under Teague v. Lane is an open question, and I'm sure me and the government take different positions. What is clear—
Are you contending that it's a substantive conduct rule under Teague?
Your Honor, I'm contending that now. I do think if this court needs to reach that question, respectfully, I think supplemental briefing. I do not think it's an easy question, honestly. I do believe it is retroactive.
Is it a procedural rule or a substantive conduct?
It changes the punishment. So Your Honor, I'm sorry, you asked a direct question. I think it is a procedural rule because it gets to the calculation of the guidelines error. And again, I'm certainly happy to keep talking about it. I do think it—
Why don't you raise that on rebuttal if you wish, okay?
Yes, thank you, Your Honor. Thank you very much.
All right, we thank you. Mr. Brogdon, let's hear your side of it.
Good morning. May it please the court. My name is David Bragdon, and I represent the United States. This case does squarely present the issue of whether Chambers should be extended to cover non-retroactive error. And I'll talk about Chambers a little bit in a minute. I'll also talk about how correcting the error doesn't really correct the error in most of these cases as well. But before I get to that, I did want to state it is the government's strong position that the error here is not retroactive. It's not retroactive because it doesn't change the statutory maximum or minimum at all. And so it's just a function of the guidelines range. It doesn't extend additional punishment beyond the statutory maximum. And this court and others have held that that a guideline—
But it hasn't been ruled retroactive.
That's correct as well. It also has not been ruled retroactive.
Whereas in Chambers, there had been a ruling that it was retroactive. I think the question you were talking about was the Teague question.
Yes, that's right. And so there, the courts that have addressed this error have held that it's not retroactive. And the ones we cited a couple from district courts in our brief.
Mr. Bragdon, this is Judge Niemeyer. Chambers is my big question mark in this appeal, and I probably should ask your colleague this same question, but it's hard for me to understand how Chambers handled retroactivity. It looks to me as if the government in Chambers did raise that as an issue, and Chambers rejected it. But I would really like to hear your interpretation of Chambers, because it seems to me Chambers is written more broadly such that retroactivity is irrelevant, but I may be wrong on that.
Thank you, Your Honor. I'll bring a couple of quotes. At the very beginning of Chambers, when it describes its holding, it says, quote, "We now hold that any guideline error deemed retroactive, such as the error in this case, must be corrected in a First Step Act resentencing." And then it goes on as it examines the error in its case.
Yeah, but my point is this, I suppose. I recognize that. But if it was retroactive, then that narrows the scope. And there was a discussion of Hedgewood in that regard. But the Chambers Court didn't stay with the narrow scope. It seems to suggest I may be wrong, it seems to suggest a resentencing is required. I mean, they even cited the Pepper case from the Supreme Court. And if there's a resentencing required, then you apply everything that's been corrected. You start over from scratch, so to speak, at the sentencing, and everything's free game, including conduct since their original sentencing. So that's a conundrum for me. I'm very interested in hearing how you can explain that for me.
Well, I don't think that Chambers held or suggested that a plenary resentencing is required. And there is a specific footnote in there that says, district courts have held that we agree that the error here can be corrected without plenary resentencing.
But it does use language. It does use language that this is not simply a modification or a reduction. It says we're imposing a new sentence, and it goes ahead and rejects a C2 interpretation the Supreme Court made, which was rejecting a plenary sentencing. And then goes on to say during the resentencing, you do the factors under 3553A, and finally it's troubling because that reading of Chambers opens things up more than I think Congress intended, and so that then brings the question is, how free are we to constrict, and where can we constrict Chambers to get more in line with what I think was intended, was to fix the Fair Sentencing Act?
And I guess to answer that question, I do not read Chambers that broadly. I think that certainly Chambers uses the language about the retroactive nature of the error a lot. It also specifically references Miller in finding that a Simmons error was retroactive, and Miller relies on the Teague line of jurisprudence to do that. And I think when Chambers discusses recalculation of the guidelines and what's going to happen in this regard, it's not radically different than what the other courts have held should happen in a sentencing, even when they're not correcting non-retroactive error. For instance, I think almost all of the courts, to my knowledge, agree that the 3553A factors should be considered. I think that they agree that post-conviction conduct can be considered.
And it applied 3661, and 3661 has been construed in Pepper versus United States. And basically the court made it pellucid in Pepper that you start over. You can bring anything that you could have if it was an initial sentencing. And the Chambers Court spent some time in doing that to justify bringing in conduct, post-sentencing conduct for the resentencing. It's hard to square away, and maybe there are ways we can snake through it, but I'm just looking for your ideas that takes on Chambers fairly. I don't think we should be extending Chambers, and I'm only expressing my own initial reactions now to the argument, but it seems to me, how do we, but at the same time being faithful to Chambers, at least to its core holding?
I guess when I looked at Chambers, there's a point in time where they compare a retroactive error to, I guess, a typographic mistake, or just a simple, clear mistake that's readily fixable. And when I
wasn't Chambers Court addressing the government's position there? In other words, basically, impliedly rejecting it, I think, but.
I think so. I think so. The way I read that language is to suggest that when an order is retroactive, when it's the order that's so fundamental that courts have held it should be applied retroactively, this tool to fix crack powder disparities can also be used to correct those retroactive errors. But I don't think Chambers would have used the word retroactive so often in its case and at such key moments in describing its holding if it was already ruling on what to do with non-retroactive error. And
So why would there be the need, if we were to read Chambers as authorizing a resentencing? Why would there be the need, when you resentence, you apply the existing law at the time of resentencing? Why would there be the need to even discuss retroactivity? Retroactivity was the gateway to get all of this under the Fair Sentencing Act, I suppose, or the First Step Act.
I think that Chambers was incorporating the principle Teague v. Lane of retroactivity into the First Step Act as a way of viewing, because it is another type of post-conviction proceeding. Teague v. Lane applies to habeas post-conviction proceedings. This is a different kind, admittedly, but in considering what other errors besides crack powder to consider, the court and Chambers incorporated this mechanism to determine whether or not the error should be correctable. And I do think I did want to say just a couple words on the effect of this. I mean, there's a lot of talk about correcting the error. From the government's perspective, there is no way to correct an error in a case like this, even if the court wanted to, because the parties relied on the law as it existed at the time. In this particular case, the government proposed a plea to the defendant that allowed him to plead guilty to count one, which at the time qualified him as a career offender and now doesn't. But counts 2 and 3 also qualify him as a career offender. And if the law had been what it is now at the time, the government almost certainly would have insisted on a plea to count 3. And the defendant would still be a career offender in this case. And so if we allow non-retroactive errors to be quote unquote fixed, if we allow them to be changed, what we create is arbitrary results, not what would have happened.
If I understand the argument that the defendant is making in this case, the intervening change in law required a resentencing, not just a modification or reduction, required a resentencing. And in imposing a resentencing, you start over and do everything that you would have in initial sentencing, as Chambers relied on Pepper and 3661. I think that's the argument, that there is no necessity to look at retroactivity because during resentencing, you're going to use the current law. And that's what I thought their position was.
Well, this court specifically distinguished the Fifth Circuit's opinion in Hedgewood by saying that Hedgewood thought a full or plenary resentencing was necessary. And it said Chambers did not request a plenary resentencing and certainly does not need one to correct the sentence error. And so I don't read Chambers as requiring a full resentencing. I think that it's a narrower approach than that. It is looking at fixing this particular issue the crack powder disparity. And then while doing that, Chambers determined that courts could look at retroactive error and also consider that in making the change. But
I don't think it just said could look at retroactive error. The chamber said it must look at retroactive error.
That's correct. I apologize for that misstatement. But yes, that courts must look at that. But it didn't go further than that. It didn't say a full resentencing is necessary, and it didn't say that non-retroactive error also needs to be fixed. And this is supposed to be a limited remedy. The as if language here that is the controlling language. I think of what would that sound like if we were using it in real life. And in the brief, I used the example of we need to revise our budget as if the new contract will be signed. Or another example would be buy groceries as if they will need to last 2 weeks. Or pay the employees as if there were no government shutdown because we have multi-year funding. What all of these examples illustrate is when you use as if, you're narrowing in on one specific modification.
But counsel,
well,
I think
understand that, and I think it's a powerful argument, but certainly the other circuits have latched onto it. But the question I have is, does that just re-argue Chambers? Are we trying to, I mean, I think the order that came out, I think I voted against, I think I voted for rehearing in bank on the grounds of Judge Rushing's dissent. And the as if clause was brought up in her dissent, but and it's a powerful argument, but the question I have is whether Chambers either explicitly or implicitly rejected that, and whether in revisiting the as if argument, whether we are just trying to re-argue the Chambers case. That's the conundrum. At least that's the problem for me is, what we obviously owe respect to circuit precedent. That's perfectly clear. And then the question comes down to, well, what does circuit precedent mean? Is it the narrow express holding that that is on the first paragraph or first page of Chambers, where they explicitly use the term retroactive? And are we justified in sort of following that phraseology quite literally, or does precedent extend beyond that and oblige us to follow more general statements that are offered in support or explanation of that narrow holding? And sometimes the more general statements that are offered in support of a narrow holding are broader than the expression of the narrow holding itself. And so what I'm asking you is, what does respect for circuit precedent mean? Just strictly going by the literal language of that first page with that word retroactive in it, or are we required to follow certain more general statements that may indicate a broader holding, as Judge Niemeyer indicates, that we're in a resentencing, and that means you apply current law. So what does respect for precedent mean in your view?
Thank you, Your Honor. I think respect for precedent does go beyond than just a literal looking at, okay, this, we can distinguish this language. I think the court should look at the opinion as a whole. I agree with that. But I will say that retroactive does not just appear on the first page. It appears on 5 separate pages. It permeates the opinion, both as it's explaining its holding and as it's distinguishing other cases. And so I think the way I read Chambers is it did not reach this issue. What it did is it said, this kind of error, what we have here, retroactive error, we want that corrected. But I don't think the logic or the language suggests that the court also should correct all other error. And I think in doing this, this court charted a middle path between what is now a circuit split. You have circuits who say, we're never going to fix error, and circuits that say do, and Chambers saying this kind of error, the kind that under our Supreme Court line of cases is fundamental enough that we fix it in habeas cases, that kind should be corrected here. And so,
well, let me ask you this: would the district court, if it's not required to apply non-retroactive error, would the district court be permitted, if it wished, in its discretion, to apply non-retroactive error? In other words, you have two rather absolute positions, and one is that you're not required to do anything other than apply the Fair Sentencing Act of 2010. And then you have the other situation that says you're required to, once you get into a 404B hearing, you're required to conduct a plenary resentencing. And then you're saying that, well, Chambers articulated a middle ground between these two absolute positions, and say, yes, you're required to apply the retroactive, but not the non-retroactive errors. And what I'm asking you is there another middle ground? Are there essentially two middle grounds? And is there another middle ground that would say, with respect to non-retroactive errors, that the district court retains a large degree of discretion over sentencing, and it is permitted, but not required to apply non-retroactive error?
I see I'm over my time. May I answer the question?
Yeah, sure.
I think that my answer would be, I don't know I haven't thoroughly considered that issue, but I don't know that would be a good middle ground to draw. Certainly the district court has an abundance of discretion in deciding whether or not to reduce the sentence and how much to do so. And so we agree completely with that discretion. In terms of the guidelines range itself, I think it makes less sense to say, well, it can modify it to make it new, or it cannot modify it. I think the guidelines should probably be one thing or the other, consistent in all cases. And so I would not propose that as a middle approach.
Do you think the middle ground was in holding that retroactive errors must be applied, but not non-retroactive errors? You think that's the middle ground between the circuit split?
Yes, Your Honor.
Can I ask you one question? If we were to say that a district court could not correct non-retroactive errors, how would we explain the two aspects of Chambers? One, that courts are instructed to recalculate the guidelines anew. And two, they're allowed to take in post-sentencing conduct into the new sentencing. What justifies that if it were limited just to retroactivity?
Thank you, Your Honor. So with regard to the first point, with respect to recalculating the guidelines, that is something that commonly has to be done in these cases, because many times when the statutory range changes, the career offender guideline range changes as well. Very often there is a recalculation of guidelines, and regardless of the circuit you're in, the court has to look at even the crack powder distinction may change the guidelines. And so really what this court would be saying is, of course you recalculate the guidelines, and in doing that you change anything related to the Fair Sentencing Act affected, and then you also change retroactive errors, but you do not change every other error because this is a limited remedy. Regarding the second question, which relates to the scope of the sentencing, I think what the court would say is 3553, or these factors that we consider, the discretion that a court has in sentencing, that's a part of what's built into the First Step Act itself. The court specifically says that a district court has discretion to, well, it doesn't say those exact words, but it says that the district court may reduce a sentence, and then it says nothing in the act requires it to do so. So there's certainly a lot of discretion built in. When Chambers referenced what's going to occur, it simply specified what the court should consider in exercising that discretion. We do not.
All right, thank. But Judge Niemeyer, do you have further questions that you wish to ask?
Well, I don't think I need to ask them, but I have a lot of further questions. I'm trying to figure this out. But thank you.
Well, I don't mean to cut you off.
No, I'm satisfied. Thank you. Let's move on.
Judge Quattlebaum, do you have some further questions you would like to ask?
No, thanks. I'm fine.
All right. Well, let's hear then in rebuttal from Mr. Brignac.
Thank you, Your Honor. I want to make one sort of quick point and then sort of get into, I think, some of the issues Judge Niemeyer raised to make sure our position is clarified. And I guess I would just say, obviously, if the court thinks that it is compelled to really hinge things on this Teague v. Lane retroactive distinction, it is going to create a lot of litigation. If every time an error like this comes up in the district court, and then certainly on appeal to this court, we're going to have to be doing a Teague v. Lane full analysis. That may be what this court holds, but it is going to create a lot of work, and I'm not sure that's what Congress intended.
Why would that be, Mr. Brignac? Because in the Chambers case, you had a very clean holding of retroactivity, and why wouldn't going forward, either you have a clean holding of retroactivity with respect to the rule, or you don't?
Because, Your Honor, if it had not been held before, then I think if I was reading Judge Quattlebaum's original question many minutes ago, we would have to do that in the first instance in the district court. So it would create this litigation. Why
wouldn't we require a prior ruling of retroactivity? I mean, which the district court is to take as a given or not given. Either it has been previously ruled retroactive or not.
Well, Your Honor, and there would have to be a first case where that would where that would come up, so it's still going to have to be done. You know, Judge Niemeyer, you were talking, and I just want to be clear about plenary.
Let me have an answer to that question. Why wouldn't that be a cut and dried thing the way it was with Simmons and Miller? And because one of the things that would concern me about what you said was that district courts ought not, and the judiciary ought to be very cautious about making retroactivity holdings on their own. In this case, Congress was the vehicle for the retroactivity when it talked about the as-if clause in the Fair Sentencing Act. But I find it seems to me that when you're saying this is going to require a lot of litigation, you seem to be reposing the authority in the judicial branch to hold or not to hold certain guidelines errors to be retroactive. And I wonder whether that isn't a point for Congress or the Sentencing Commission or the Supreme Court.
It was cut and dried in Chambers, Your Honor. Respectfully, it was not cut and dried in Miller. There's gonna have to be a point where somebody goes through the trouble of figuring out the relatively complicated Teague v. Lane analysis. To go back really quickly, Judge Niemeyer, you know, in Wersing, and it was footnote 1 in Wersing, these are not plenary resentencings. The defendant does not need to be present. These are not full resentencing. Defendant does not need to allocute. The Peters case talks about how you will not be able to readdress facts that were previously found, only where facts were left open. But what you do is calculate the guidelines correctly. And Judge Wilkinson, your last point to opposing counsel, and my light is on, may I just finish for 30 seconds?
Yeah, go ahead.
Thank you, Your Honor. Your last point was sort of, could a district court choose to apply, say, Norman error or not? And the answer is no, it couldn't. If this court agrees with the government here, it is telling district courts, it is telling the defendants, it is telling their family members, it is telling everyone that this is a mistake and you have to make the mistake. Someone else will come in 5 minutes for his sentencing, and everyone will agree he's not a career offender. But the guy who was there for a 404 beforehand, even though...
Well, I know, but that's a general argument in favor of retroactivity itself, because that's always the case when you don't hold something to be retroactive. You have someone sentenced at one point in time, and maybe at a different point in time, courts interpret something in a different way. So, I mean, the point you just made seemed to be a general argument in favor of retroactivity, which I think opens up a large number of philosophical questions. But why don't you go ahead and just make a concluding statement, if you would, Mr. Brignac?
The red light is not a time to get into philosophical statements. Your Honor, Norman error was error in 2009. Norman error is error today. There's no reason district court should be barred from recognizing that error and correctly calculating the guidelines. Thank you.
All right. Judge Niemeyer, do you have some questions of Mr. Brignac?
No, thank you.
Judge Quattlebaum, do you have some further questions?
I do not. Thank you.
All right. I want to thank you both for your fine arguments, and we very much appreciate you being here. I'm sorry we can't come down and greet you and thank you for the efforts that you've made, but we very much appreciate them nonetheless. And now I'm going to ask the courtroom deputy to give us a 5-minute break, and let's resume in 5 minutes with the County Board of Arlington versus Express Scripts. All right.
Thank you.
This honorable court will take a brief recess. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Ms. Bedell, do you please commence your argument? Good morning.
Good morning, Your Honor, and may it please the court. Adriana Riviere for appellants, the ESI Mail Pharmacies. We ask this court to reverse the district court and find that we properly removed the case under the federal officer removal statute. The ESI Mail Pharmacies satisfy the acting under requirement for federal officer removal for two primary reasons. First, ESI Mail Pharmacies operate the TRICARE mail order pharmacy for the Department of Defense to assist it in fulfilling its statutory mandate to provide pharmacy services to military members and their families. Absent the ESI Mail Pharmacies operating the TRICARE mail order pharmacy for the government, the Department of Defense would have to administer the mail order pharmacy itself. This fact is undisputed, and the Department of Defense has acknowledged that the government cannot provide this mail order service directly without private contractor assistance. The Department of Defense relies upon ESI Mail Pharmacies.
Let me ask you one question that I had, and that is, in our Baltimore case, we said, well, that belongs in state court because it was an off-the-shelf contract, a standard kind of contract for fuel. And you say, no, this is something different. But how do we distinguish, the government contracts with hundreds of thousands of private contractors on everything under the sun. How do we distinguish those contracts, which ought to be litigated under whatever contracting law in state court, from those contracts where the contracting party is acting under government direction? In other words, what rule would you give us to distinguish the off-the-shelf contract with the contract that you are claiming puts your party in the acting under category?
Your Honor, thank you. It's right in the standard announced in Watson, applied in Sawyer, and in BP. Basically, the way you distinguish it is when the contractor is assisting the federal government in fulfilling a basic task and does so with some subjection, guidance, and control. That is exactly the situation here. We do not sell any off-the-shelf products to the government. We don't sell any products, period. Instead, what we do is operate the TRICARE mail order pharmacy. This is a custom designed program that the government has to provide to its military. There is no other company that runs the TRICARE mail order pharmacy. We are the ones, and it is governed by a 51-page statement of work. It's governed by TRICARE statutes, by TRICARE regulations, by TRICARE manuals, and these are not.
How detailed in the contract with the DoD are the requirements, the statutory, regulatory, and contractual requirements? There are probably three sets of requirements here. How detailed are those requirements, and does it matter how detailed they are?
It does matter, Your Honor, how detailed they are, because it goes to the whole control, subjection, guidance, and control. And in this case, they are more detailed than any other case that was faced the court. Basically, every single aspect of how the TRICARE mail order pharmacy runs is specifically within the statement of work, which is itself incorporates the TRICARE statutes, the TRICARE regulations, the TRICARE manuals. These are voluminous and very, very specific guidance.
So they're not in the contract itself, except to the extent that they're incorporated by reference?
They are both, Your Honor. So both the 51-page statement of work has extremely detailed specifications, and those are even themselves supplemented by thousands of pages of manuals, of statutes, of regulations. This is one of the most, if not the most, regulated programs that the government offers. Which makes sense, Your Honor. This is a uniform program to be provided to the military and its families. And the ESI mail pharmacies exercise no discretion in how to operate the TRICARE mail order pharmacy. The Department of Defense dictates the requirement.
Does it make a difference that your client is a subsidiary of Blue Cross rather than, or a subsidiary rather than the contracting party itself?
It makes no difference, Your Honor. And one of the entities is a subsidiary of the contractor, the other is a corporate affiliate. But it makes no difference because it is undisputed that we operate the TRICARE mail order pharmacy for the government. The district court recognized that. It's in our declarations, and it is in fact true. We operate this program, and we operate it in compliance with all of the requirements that I listed out. And the mail order pharmacy administration, yes, Your Honor.
Counsel, this question probably doesn't make a difference in the outcome, but there is a party that is a direct contracting party with the Department of Defense, and I think they're a defendant as well. Maybe I'm wrong about that. I thought they were, though, and it's curious to me that they didn't undertake to remove under this provision. Just as a matter of fact, is that correct? Did they undertake to remove, or have they consented? I mean, what's the status of the direct contracting party?
Yes, Your Honor. So the direct contracting party was originally sued, and it did remove along with other defendants on other grounds, not federal officer grounds. Those grounds had been upheld and had been sufficient for dozens of cases that were transferred into the MDL. It was this case that was an exception, was remanded. Now the plaintiffs made a decision to amend to add our mail order pharmacies, and when they did so, that started our ability to remove, and that's when we removed. And of course, our corporate affiliates consented along with the other defendants.
Okay, let me follow up with another question. The district court ruled under the acting under requirement of the statute. As you know, there are two other requirements. Assume hypothetically that we agree with you on the first. Are you asking us to remand to the district court to analyze the remaining requirements, or are you asking us to rule on those and explain, why, whatever your position is?
Yes, Your Honor. We believe that this court can appropriately rule on all three of the requirements. It's in the record. It was briefed before the district court. And even if you look at the district court's opinion, there are parts of the opinion that, although addressing specifically acting under, do go towards the second and third prong. And we've stated in our brief, and briefed by the county as well, we believe there is sufficient information in the record, and it would be interpreted as a matter of law, and so de novo review in any event. And so we believe that there is, this court can rule on the second and third prongs and remand with instructions that the case was appropriately removed on all three prongs of federal removal.
Oh, one more, and I'll try to be quiet. But on the third prong, the defendant, the plaintiffs argue that I think they're alleging that that your clients don't have that nexus, don't have that directed conduct provision, because what they're really claiming is that you should have recognized that the opioids are being dumped in a disproportionate amount into Arlington County. Not so much that just the way you're carrying out your contract, and that somehow doesn't satisfy that third prong. Could you respond to that, please?
Yes, Your Honor. So what's required is that there be some connection or association between what's alleged in the complaint and the federally directed activity. It's a low bar, and we very easily meet it. Here, what's happening is that the plaintiffs are challenging how the ESI mail pharmacies administer their services. Basically, they challenge, how we monitor, detect, report, fill prescriptions. All of that conduct is specifically and in great detail controlled by the contract. For example, the government tells us exactly how we're to use our data, exactly how we're to monitor prescriptions, exactly how we are to restrict controlled substances prescriptions, including opioids, if there is any concern about fraudulent or criminal diversion of opioids, which is what the county is claiming that we failed to appropriately do. And there is no de minimis threshold, but even if there were, we very easily meet that threshold. We have 29.5% of our mail order prescription opioid claims are for TRICARE members in Arlington County. So there's no question that when the county challenges how all opioid prescriptions are handled, that necessarily includes the prescriptions that we handle for the TRICARE mail order pharmacy specifically. And Your Honors, there is, if the court were to not uphold federal officer removal in this case, it could actually do damage to an important federal program, specifically in the form of interference with the federal government's uniform operation of the National TRICARE program. The Supreme Court has emphasized that the removal statute's basic purpose is to protect the federal government from interference with the government's operation. And the federal government here, both through its legislative and executive branch, has decided exactly how it wants to provide a mail order pharmacy benefits to the military. The federal government has decided to offer a uniform nationwide program. There's one nationwide contract, one set of operations manuals, one TRICARE mail order pharmacy, and it achieves the Department of Defense's stated interest in assuring a uniform national health program for military families. And the contract and the manuals require the Department of Defense's use of its own formulary. That's a list of approved drugs, including opioids. It also requires specific prescription processing and dispensing. It also requires exactly how prescriptions are going to be monitored for potential abuse. Yet the plaintiff here is one county, and it seeks to change, and it seeks to halt how our current practices, and it seeks to impose liability for how we provide these services, which include our services to the TRICARE mail order pharmacy. If the state court were to order us to change our practices, that court order would apply in one county out of thousands around the country, and the federal TRICARE health program would no longer be uniform. Now, the government here has decided exactly which list of approved drugs will be on the formulary, exactly which clinical management and clinical review to impose on those drugs, for example, prior authorization and quantity limits, and exactly how it wants to review data to determine potential abuse of controlled substances, and what to do in the case that it does find controlled substances. But the county wants to impose its own standards for each of those plan designs, and it seeks to change how and where all opioids appear on all formularies, and to dictate what it believes is the appropriate clinical management of all prescriptions, and how data we collect should be used, and exactly how prescriptions should be restricted. This is an obvious attempt to interfere with the federal government's operation of the TRICARE pharmacy benefit. In short, the remand order should be reversed to avoid interfering with fundamental government operations and federal interests. And I'll reserve the rest of my time for rebuttal.
All right, thank you very much. Mr. Conrad, when you're ready.
May it please the court, Johan Conrad on behalf of the County of Charlotte, Virginia. The fundamental question before this court is whether federal officer removal jurisdiction.
Mr. Conrad, this is Judge Niemeyer. I find you breaking up a little bit. Is there a microphone close to you? You can pull closer, or?
I will pull closer, Your Honor. Thank you for pointing that out.
Yeah, sure.
Is that better?
Much better.
Thank you. So I'd like to cover 4 primary areas, which I'll summarize quickly and then go back to, but I'm also going to talk a little bit about the procedural posture, which I had intended to skip, but given the question that was posed, I will touch on that briefly. The 4 areas, number 1, the factual record before the district court and the district court's reasoning regarding the arising under prong. Secondly, the question Judge Wilkinson asked a few minutes ago having to do with the fact that this is essentially a consumer product, and so under this court's holding in the BP case does not qualify for federal officer removal jurisdiction. The third has to do with the nexus question, which was raised a couple of minutes ago, and the fact that Arlington County did not sue on this DOD contract, did not mention this DOD contract, this suit has nothing to do with this DOD contract. And then the fourth thing I'll talk about is just the overall purposes of federal officer removal jurisdiction and the fact that this particular case does not fit within those, and there is no advantage or reason that this particular case should qualify for federal officer removal.
Let me just,
Mr. Conrad, I don't mean to throw you off your argument, and I know you're going to get to it, but the one thing that did concern me was that your opposing counsel has indicated that that the 5th and 8th and 11th circuits have allowed local Blue Cross entities to remove under the federal officer statute. And so they say there's a considerable weight of circuit authority allowing removal in these sorts of circumstances, and in fact, it involved local Blue Cross entities. So would we be cutting against the grain of those various circuits if we were to rule in your favor?
No, Judge Wilkinson, you would not. So each of those cases arises in the exact same and very unique factual situation. Every one of those cases involves a Blue Cross entity that is acting on behalf of the Office of Personnel Management and standing in the shoes of the Office of Personnel Management to bring subrogation actions to recover monies, the monies to be placed within the federal treasury. And so what you have in each of those cases is a situation where the Office of Personnel Management has paid out federal government funds to beneficiaries of federal health care plans. Those beneficiaries have then filed personal injury actions or related such actions and have had recoveries. And so in each of those cases, the question is, or the suit involves.
Was there a contract with the Office of Personnel Management?
There's a service agreement between the Office of Personnel Management and Blue Cross Blue Shield. But
So there
Cross,
was a contractual arrangement.
It is, Your Honor. But
So
Blue
then
Cross,
why is there necessarily a distinction here? It seems to me that I'm concerned because I think this is a very important federal program in dealing with nothing less than being able to fulfill prescriptions for service members. And so we're talking about the health of our military forces. And that would seem to me to, why doesn't that just go to the heart of federal operations?
well, there are several distinguishing circumstances here, Judge Wilkinson. Number one, as I mentioned before, each of those suits that we're talking about, each of those cases that come from the other jurisdictions, each of them is actually a lawsuit that directly addresses the question of whether or not the funds will be available to be placed directly into the federal treasury. So each of those suits involves a very specific attempt to bring money into the federal treasury and an attempt to thwart money from going into the federal treasury. And you have a circumstance where Blue Cross Blue Shield is standing clearly as an agent. And Your Honor, this gets a little bit more to the nexus question than it does to the arising under question, because the nexus in those cases is on all four. And so here,
let me ask you if I understand your claim clearly in this case. As I understand it, you're not claiming any problem with prescribing an opioid. I gather you're claiming that the prescribing opioids in numbers or excess where they're being reused improperly in the community is the problem, not monitoring the prescriptions well enough. Is that what I understand you're arguing?
that's accurate, Judge Niemeyer. And
if that's so, it seems to me then we should not be focusing on the fact that the opioid is just an across-the-counter item like the gasoline was in the BP case, but rather it's focusing on the lack of monitoring or the lack of care in dispensing opioids. And in that regard, aren't the two pharma subsidiaries in this case really dispensing opioids under controls specified by the federal government in the master contract?
They're not, Your Honor. And I think that's a factual question that you can answer simply by looking at the actual contract here. And we've identified.
You're also talking about the working agreement too, right? The working
statement of work. Yes, sir.
Statement of work, right?
That's right. So if you look, it's at Joint Appendix, starts at Joint Appendix 638, which is the mail order pharmacy portion of the statement of work. And so 638, it's the bottom of 638 and then the top of 639 of the Joint Appendix. And with respect to the mail order pharmacy, the statement of work says, for all medications, and this is at the very second sentence, top of 39. For all medications dispensed through TMOP, which is the mail order pharmacy, the contractors, and by the way, the contractor here, and we haven't even gotten to this yet, is not either one of these removing defendants. The contractor.
No, it's the parent. It's the parent.
That's exactly right. The contractor's tracking and dispensing procedures shall comply with federal and state law and all applicable state board of pharmacy requirements. So if we back
But
up,
this is not just a compliance question, because I think Watson makes the point that if it's just a compliance question with federal regs, that's not enough. But doesn't a contractual arrangement differ from a suit that sues an entity for a failure to comply with a federal regulation or whatever? I mean, this isn't just a matter of compliance. It's a matter of it's a matter of contract, which seems to me very different if the contract specs are quite detailed as they appear to be, and the contract gives the federal government an awful lot of authority, even to the extent of altering its terms, and it gives it auditing authority. I'm just wondering if a suit for non-compliance with some arguable federal regulation isn't very different from what we have here.
Judge Wilkinson, let me answer that in two parts, because I think you're both right, but I think that it's not quite capturing the full picture here. So first of all, you're correct that unlike in Watson, in which we're dealing with tobacco regulations and not a contractual relationship, we are dealing with some species of a relationship here. We argue, and Judge Tringa found that the contractual relationship wasn't close enough between the federal government and these appellants. But I think there's an even perhaps more on point response to the question that you just asked than that one. And that is to focus back on what is the point of federal officer removal jurisdiction. And remember, in Watson, the Supreme Court talks about the history of federal officer removal jurisdiction. It says, for example, you have situation in 1920, the Maryland v. Soper case, where the chauffeur for some bootlegger federal agents was a state court tried to try the chauffeur, and the Supreme Court said, no, you can't do that. Because that's the state court trying to interfere with federal law and federal agents trying to carry out their duties under federal law. So really what we care about when we're talking about federal officer removal is protecting the immunity of the federal officers and those who are essentially standing in the shoes of the federal, such as the chauffeur. Now, let's go to the language I just read to you in the statement of work at the top of page 639 of the Joint Appendix. This particular statement of work specifically said that the parties, the private contracting parties under this particular contract are going to remain or need to remain in compliance with state law and all applicable Board of Pharmacy requirements. So the case, first of all, and then to get back to the lawsuit that Arlington filed, the lawsuit that Arlington filed isn't suing these folks for anything that they did under this contract. It doesn't have anything technically to do with this contract.
Well, how can you say that? I mean, you're not pointing to, you're not saying they breached the contract. I get that. And you're not referring to the details of it. But it seems to me what you're arguing that in the context of carrying out their contractual responsibilities here, that you want them to have done something that they have not done. So it seems like you're in effect saying that even though the contract says you have requirements 1 through, a bunch, whatever the number is under this statement of work, we want there to be another one, which is you have to have this special attention to potential dumping of opioids. I get that it's not a breach of the contract, but under the nexus issue, it seems like it relates to it. I have a hard time understanding how it doesn't relate to it.
Your Honor, our lawsuit says that a number of defendants, including these two, with respect to these two appellants who are mail order pharmacies in connection with their mail order pharmacy duty, have flooded Arlington County, flooded the country, frankly. The numbers are somewhere in the neighborhood. These two appellants, 19 billion MMEs across the country of opioid during a particular period, and have flooded Arlington County with opioids, caused lots of damage, and in doing so have not complied with their obligations for particular suspicious order monitoring and things of that nature, which include state board of pharmacy requirements, which would include state law. And so there's nothing in our lawsuit that says you did or did not appropriately comply with this particular contract. This contract, according to these defendants, happens to be a way in which some residents of Arlington County receive some
But counsel, is it, aren't you just making their argument for them right there? It looks to me like you're complaining that they didn't comply with state law or state pharmacy requirements, but that's exactly what the contract says they must do. It seems to me like you're actually making their point that by not complying with those requirements, there is a provision. Now, don't get me wrong. I'm not, what you said about, flooding the market, I'm not trying to minimize any of that. I'm not talking about the merits in any way, shape, or form. I just don't understand how, quite frankly, using the provision you're talking about doesn't almost ensure that it is at least meeting the third prong of the test. Maybe I'm misunderstanding you, but that's how it appears to me.
Well, Your Honor, I think what you're doing is there's a problem if you conflate federal officer removal purely with the terms of a contract and just assume that if there's a contract at issue with the federal government, that therefore federal officer removal must apply. And you can't reach that conclusion when the point of federal officer removal is to preserve federal immunity. And here you've got a contract that says not only are we not concerned about federal immunity from state actions, we specifically say the state laws still apply.
Yeah.
So, it seems to me in the contract, there are independent requirements that the federal government imposes. I'm just looking at page 654, which relates to prescription monitoring initiatives. That type of regulation throughout the document, the statement of work, seems to me that the government wants a certain level of compliance also, and that in order to satisfy the government standard, there's some auditing that is authorized, and that's independent of the state. I mean, the federal government doesn't suggest that the state law ought not be complied with. It actually requires it, but the federal government has its own standards that are imposed on the pharmacies and are part of the TRICARE program. The question is, why isn't that more than just compliance with state law?
Well, two issues, Your Honor. Number one, it's important to remember who these appellants are. And these appellants are the mail order pharmacies who, by their own evidence, are in charge of just taking care of the mail order portions of this particular.
Well, in that regard, that's a big point you make, and it might be very legitimate, and I'm very interested in it. Your argument, I gather, is that Express Scripts, Inc. is the contracting party, and that the subsidiaries, or the affiliate, one's affiliate, one's a subsidiary, that they're subcontractors of Inc. And the two pharmas are really working for Inc. and not the federal government. But explain to me what the directed to comply with the government contract. How's that factually set forth?
Well, I'll give you that explanation, Judge Niemeyer, in 1 second. I just want to close the loop. The part that you just referred to a second ago about the order monitoring program, I remember the page, I think it's page 659 of the joint appendix off the top of my head. That is not a piece that appears within the mail order. So it's a critical distinction for purposes of your specific question about that particular section of the contract.
You mean that the
Secondly,
prescription of monitoring requirements in the statement of work do not apply to the pharmas?
well, Your Honor, let me answer your second question to answer that one.
Okay, yeah.
So the contractor here is Express Scripts Inc. Express
Right.
Scripts Inc. is a defendant, and they did originally remove this case at a time when neither one of the two appellants were a party to this case. They did not raise federal officer removal. They raised other bases. Judge Trenga rejected those other bases and remanded the case. The case was then amended after remand while it was in state court. These two appellants were added as defendants because they had
Mr.
not
Conrad,
raised
when
two-
I'm listening to all of this, I'm wondering if we rule in your favor, whether that isn't an extremely broad ruling. And I'm thinking, for example, of military contracts and procurement contracts for certain forms of weapons, very complicated and advanced aircraft, submarines, different parts that go into sophisticated military equipment. And if we rule in your favor, and I can see a lot of state court suits being brought, mainly the kind of suits that were present before the Supreme Court in Boyle, that the design of these military aircraft, and they said, was defective, and that this part was left out, and as a result, there were serious accidents to military personnel, and I can imagine all kinds of tort suits being brought. And under your view, the fact that the contract with the military contractor contained all kinds of specifications about how these weapons should be designed and manufactured, all of those would have to go into state court, and we could be just as this suit deals with the pharmaceutical health of the military, the suit in Boyle and others deal with the proper equipment of the military, and you can bring these kinds of suits against all kinds of military programs, and if they were litigated in state court, there's much greater danger of chaotic rulings and disparate rulings and requirements and this and that, and I realize that federal courts are no guarantee of perfect uniformity. We have circuit splits and the like, but they do provide a greater degree of uniformity. And isn't that terribly important where we have a federal interest unquestionably, which is the United States military and its health and equipment, and we're in danger of pulverizing and parochializing that a very significant federal interest, and that really concerns me greatly.
Your Honor, my time has expired, but could I have a second to respond to that question?
You certainly may.
Thank you. So what you're referring to with Boyle and some of those other cases is obviously the government contract defense. The existence of a federal defense is one of the three prongs talked about removal. So the government contractor defense here, oil concern that you've raised, is one of the three prongs. We're not, and so far, frankly, in this argument, we haven't even touched on that particular prong, the existence of the
well, but I'm just pointing out the similarity because in both cases, you are dealing with military contractors, and the Supreme Court in Boyle was very concerned with the military contractor defense as providing a guarantee against important federal programs and activities being chewed up by a proliferation of state court litigation. And I simply am suggesting that there's a very strong federal interest concerned where we're dealing with the United States military.
I agree, Your Honor, and I would just suggest that we're not chipping away at the government contractor defense here. In fact, what we're mainly focused on are the other two elements here, which are the contract and the nuisance question.
Well, but they're all tied together, and it seems to me that they're all interrelated and aim to the same end, which is to sweep matters of vital military, federal and military interest, have them in federal court. There's a match between a strong federal interest and a strong military interest, and a federal tribunal to decide questions regarding it.
Right, and an appropriate
that's all I'm saying is that I think that Boyle and the kind of considerations that underlie it are one of the factors, and an important one, that feed into this kind of case. But at any rate, your time has expired, but if you have some brief concluding statement, I'd be happy to hear it.
Sure, Your Honor, thank you. And I would just say that that when you're dealing with a case like Sawyer with the naval warship, or some of the other cases that have involved the manufacture of equipment and things like that, where we're talking about the actual contractor, we're talking about circumstances all fours with the lawsuit, that federal officer removal is appropriate. And here, we're not talking about the actual contractor. We're not talking about a lawsuit that is on all fours with the point of the contract, and we're not talking about the concern of protecting the immunity of a federal officer. We're simply talking.
I do have one question, if I could, before we close out.
Yes.
You didn't really get to my question earlier, but my question is, does this doctrine apply to subcontractors when the subcontractor is an agent of the government contractor? Let's assume that the farmers in this case are agents of Inc., of the parent. The parent has the contact with the federal government. The subcontractors are working with the contractor, but the subcontractors don't have direct contact with the government. Is that still permissible removal in that circumstance?
Your Honor, I think that's obviously a highly fact-specific question, but I don't
think... It's the thing the court relied on in this case. In other words, the court focused on Inc.'s relationship and said the subs didn't have a relationship with the government. But the subs were an agency relationship. They were subcontractors to Inc., to the parent. And so the question is does that make a difference?
I think it does make a difference, Your Honor, and I think when you're completely removed from the office.
Well, they're not completely removed. They're working through the parent. In other words, the question is, can we treat the subcontractors who are agents of the contractor? Can we treat those as persons dealing with the government?
I don't think that they should be treated under the circumstances where they do not have themselves a direct relationship.
Well, why would that be? I mean, as Judge Quattlebaum mentioned earlier, the question is related to, and it's still the subs would still have related to. But what I would suggest to you is that it is natural in any kind of federal contracting relationship here that you would expect subcontractors and subsidiaries to play some sort of role in implementing the contract, because these federal contractors, you may have one general contractor with the federal government, but you also inevitably have, because there are many pieces to the federal contract, and you also inevitably have subsidiaries and subcontractors helping to execute. And as I understand it, that the subsidiaries are still bound by the contract between DOD and Inc. and the parent. And my guess is that they are subject to audit, and that they are absolutely, I think anybody that, I think that these subsidiaries are in fact audited in this case, and they're required to follow the same specs that the parent has. So I'm not sure, and I think it's a very good question, because the district court relied upon that, but I'm not sure that it makes a difference here in terms of the reality of the federal interest.
You certainly have circumstances where they're disclosed subcontractors and where there is more of a direct relationship. Here, these two appellants were not mentioned or referenced in any way in the contractor statement of work. The only reference is there is one line that says the contractor and subcontractors, paren, if any. There is no recognition of these particular subcontractors.
Well, let me ask you, does that make a difference when the contractor, let's say the contractor just hires an additional employee who's fully in charge of carrying out the program? In other words, if these subsidiaries are agents of the contractor and carrying out the statement of work, you would expect to treat them as a group, and there's no special need to observe corporate differences, is there?
I think there is, Your Honor. I mean, I think.
Okay, well, I want to know that's what I want to know. Is the case law support you on that?
Your Honor, we have not located a specific case that deals with that question on all fours. And if you read Judge Strenga's opinion, he goes through the case law and basically says, I think that there are circumstances where you don't have to have technically a direct contractual relationship, but you definitely have to have a direct relationship where the federal government officer is directly interacting with you and directly mandating the activities. And one example,
I gather in deciding this case, that's really where we have to focus, isn't it?
Yeah, and if I could just ask one question on that point, what is your best case for the absence of having a direct contract relationship? I think you said there's nothing on all fours. If we were to go to look to your best case on the importance of these defendants not being the direct contracting party, what would that case be?
I think that the case that Judge Strenga looked at a lot, which was the Mays case out of the Sixth Circuit and involved Michigan.
Yeah, I'm familiar with the Mays. I don't mean to cut you off, but I'm familiar with that one, and we can look at it. And I'm sorry to ask a question and then interrupt you, but I'm familiar with that case. So thank you very much.
Understood.
All right, thank you, Mr. Conrad, and Ms. Bedell, you have some rebuttal time.
Yes, thank you, Your Honor. So there is no requirement to sue on the contract. That has never been part of the standard. There is no requirement for there to be a subcontracts
Well,
at all.
let's focus on the question that I just asked Mr. Conrad, which is we have two subs which were moving parties, and the subs claim they're acting under a federal officer. The first prong, not related to, acting under. Is it sufficient that they are acting under a federal officer through a parent corporation?
Yes, Your Honor, it is
Okay,
sufficient.
and what's the best case we can look at for that?
Well, Your Honor, there's a few. So specifically, if you look at Sereng, which is the Fifth Circuit case, Sereng versus Crane Company, there the Fifth Circuit held that you didn't need to have direct oversight of specific acts giving rise to the plaintiff's complaint, the allegations in a plaintiff's complaint, to satisfy acting under. And it's often been recognized, and there are many cases where the courts recognize, including this court recognizes the ability of a subcontractor to raise federal defenses. And as the court in Boyle said, it is an important central purpose is for federal defenses to be heard in federal forums when there are specific federal interests involved. And here there is no question that this is one of the quintessential federal interests the government has. It's providing mail order pharmacy services to the military. And here it's very simple, Your Honor, because there is no question that we have stepped into the shoes of the Department of Defense and we administer the Tri-Care mail order.
I understand that. I'm getting more particular. I'm getting with respect to the subsidiaries. I'm calling them both subsidiaries, the two pharmacies.
I understand.
But the parent is the contracting party, and the two subsidiaries are retained as agents to carry it out. And my question is, in that context, the subsidiaries do not have direct control or contract. The government is not looking over their shoulders. The contract is looking to the parent to make sure it's carried out, and they do meet regularly to see whether it's being carried out. So the question is, really the one the district court focused on is, does that make a difference in the analysis of Section 1442?
And it does not, Your Honor, and there is no case that says that it does. Because you go back to the fundamental standard that was announced in Watson and applied by this court in Sawyer and BP. Namely, does the contractor assist the federal government in carrying out a basic function? And does it do so with some subjection, guidance, and control? Absolutely it does here, Your Honor. We step into the shoes of the government. No other pharmacy runs this. We are the licensed pharmacy.
I know, but see, you avoid the question by using we.
No, Your Honor, I mean, we, Your Honor, I mean the ESI mail pharmacy. No, we the mail order pharmacy.
Okay.
Specifically, Your Honor, we are the licensed pharmacy. So our affiliate, Express Scripts Inc., is not a pharmacy. We are pharmacy. And it is obvious that the government relies on us to carry out the obligations of a pharmacy. And it does so, and it does control us, Your Honor. It specifically controls us both through provisions in the contract where it says it anticipates the use of contractors, subcontractors, consultants, staff, agents. To Judge Wilkinson's point, it is obvious that the government knows that it has to rely on other agents to carry out its obligation. And it does audit us.
Ms. Bedell, just just to close this loop, and I think Judge Niemeyer asked you for case law, and you referred to a Fifth Circuit case that says something along the lines of direct oversight is not required. I may have understood that a little bit, but it sounds like they're also, just like Mr. Conrad said, there wasn't a direct case saying non-contracting parties excludes them from use of the removal statute. Is it fair to say that there's not a case that directly addresses that proposition in your favor as well?
Well, Your Honor, there is the case that actually the district court relied on, which is Padilla, a Western District of New York case where a subcontractor did remove. And the court found dispositive the fact that a federal officer wrote the standard operating procedures that were applied. It also found through jurisdictional discovery dispositive the fact that there was an email between that federal officer saying essentially that all issues related to operations of power would go through that federal officer. That's exactly what we have here. In fact, we have 1,000 times more here. We have not just one standard operating procedure, but thousands upon thousands of pages of how we operate. We, the ESI.
You're not at liberty to vary from any of those.
We are not, Your Honor.
You're audited, are you not?
We are, Your Honor, and that's stated in our declaration. And in fact, the contract says that the government has the right to audit both on subcontractor premises or anywhere where the operations of this contract are performed. The government absolutely anticipated that there would be work done by others, not just the named contractor. And it absolutely knows that the ESI mail pharmacies.
Well, I mean, it would be an odd state of affairs if the contractor was not free to vary or deviate in any way from the voluminous regulatory and statutory contractual requirement. But hey, the subsidiaries and the subcontractors were free to go their own way. The value of the whole point of the contract would have been undermined. The value of the contract from the standpoint of the government would be nullified, and you'd have a subsidiary acting in violation of the contractual requirements, and it wouldn't be anything that the federal government could do about it as far as the federal officer removal statute is concerned, and or that the subsidiary, but it just doesn't seem to me realistic to cut off and bifurcate the primary contracting party, Inc., from the subsidiaries when they're all part of the same contractual purpose. They're all subject to the same regulations. They're all after the same. So they're all after the same end. They're subject to the same requirements. They're audited, and it's sort of treat them differently for jurisdictional purposes is to sort of carve up the federal interest into two. Do you see what I'm saying?
Yes, Your Honor, and I realize that my time is out. If it's all right, if I could just make one further point.
Judge Niemeyer, do you have some further questions?
No, I'm fine, thank you.
Judge Quattlebaum?
I have no more questions. Thank you both.
All right. Thanks to you both. And I will ask the courtroom deputy to adjourn court for 5 minutes, recess court for 5 minutes until we're able to gather together in conference.
You know, if I were coming down from the bench and shaking your hands, I'd tell you we both did a great job today.
Thank you, Your
Thank
Honor.
you.
And that goes for me as well. Thank you both.
Thank you, Your Honor.
Thank you, Your Honor.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
All right, we're going to reconvene in 5 minutes, okay?